up slaves and hit those buttons, or I'll send ICE.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape paint. We ain't talking vapes or the color of drapes, or a gorilla in a cape. It's the good shit, just one hit. You so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, S.W.A.P, citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan. How you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation. You're a cheap imitation. Dog said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you tonight with a renewed motion denied. So we're going to go through another procedural legal error, and we're behind the 8 ball, so we're going to start throwing stuff at them that should hopefully make them pay attention, because now they're all getting wrapped up in that little lie that's being strung out. So we're going to go over some documents I'm putting together. Greetings, brother. Feel free to make comments in the chat. I'll try to do my best to read them as I go through this. But basically, we're talking about the appeal from the magistrate court, which is a local municipal court, but it's still an equitable action. So any court up the line can now handle the appeal. The next court up the line is the district court, the local district court. So we're going to put in an appeal and some other documentation, form of papyrus, so we don't have to pay the filing fees and stuff like that. We will have to pay for the transcripts, but that should be kind of minimal. And then, of course, notice of intent to sue that we sent out to the property management last time. After the fact, I realized it's supposed to go to the attorney. So we're going to be sending out a notice of intent to sue to the attorney as well. And so we're going to go over this document stuff here. Let me see, get screen share up. See what we got here. Okay. So we have in the district court for Blackhawk County, blah, 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 to the clerk of district court, the defendant appellant hereby appeals to the district court from the final orders and summary denials entered by Magistrate Abbott, specifically the denial of renewed motion to vacate. Now, in this one here, I stated the court's statutory duty as to presumption of retaliation, and he ignored that. So he denied my first motion to review the case and have the case law put on the record, such as, which is, we're talking about the merits rather than a summary denial. They have to put the merits of the case on the record, and he denied that. So we renewed the motion stating that presumption of retaliation, they have a strict statutory duty as a court. So now we have a plaintiff that denied their strict statutory duty, and we have a court that denied their strict statutory duty. Notice of appeal and statement of procedural error to the clerk of the district court. The defendant appellant hereby appeals to the district court from the final orders and summary denials entered by Magistrate Abbott. Pursuant to Iowa Code 631.13, the defendant requests a de novo review to correct the following errors of law and fact, which resulted in a denial of justice. The court's strict statutory duty, as stated under Iowa Code 631.134a, this court has a mandatory duty to render the judgment that the magistrate should have rendered on the merits. This is what I talk about with the 93 cases that I have on record down at this local courthouse, and they actually have them listed as summary judgments. None of them were actually based on the merits of the case. One important lesson I learned in all of my research: always get the merits of the case, which is the case or the law of the case. This shows that they're operating under common law. If they deny that, it shows that they're sticking strictly to their administrative process, which is the procedural legal error in inequitable action, where an equity was merged with common law. Therefore, they must follow the common law. Decide without regard to technicalities that have prejudiced the substantial rights of the parties. This is showing that the procedural legal error cannot continue because it itself is a violation of substantial rights, which we're noting here is a First Amendment right of the right to know. This is in regards to creating a record. The record was created, and now they're going to silence that record by a voluntary act of the plaintiff, which is a tactical evasion of their violations of substantial rights, as they admitted on that very record. Equity does not aid a volunteer. Address the law of the case. Because the lower court record is fragmented by the unauthorized shuffling of magistrates, this court must fulfill its duty to record the plaintiff's admission of statutory noncompliance. Error of law. Failure to enforce strict statutory duty. The hinge of this appeal is the plaintiff's admitted failure to follow the Uniform Landlord-Tenant Act. The noise hazard. Following the biblical principle of Matthew 18:15 through 20, the defendant provided repeated notice of severe environmental hazard caused by the upstairs tenant. Failure to issue the 7-day notice. Under Iowa Code 562A.271, the plaintiff had strict statutory duty to issue a 7-day notice to cure to the upstairs tenant upon receipt of the defendant's good faith complaints. Admission of ignorance. At the hearing, the plaintiff's manager admitted under oath to a total ignorance of this duty. Instead of curing the hazard, the plaintiff utilized the court system to retaliate against the victim of the hazard. Procedural error and judicial bias. The magistrate shuffle. This case was processed by 4 different officers. As I mentioned in my case 10 years ago, it too was administered by 5 different officers. Magistrate Abbott, who did not hear the testimony, summarily denied the defendant's motion to enlarge findings. This prevented the law of the case from being formally recorded. It prevented the right to know. That is a First Amendment violation. They are silencing the plaintiff's admittance of being in procedural legal error and therefore in violation of the Uniform Landlord Tenant Act. Unresisted motion. The plaintiff filed no resistance to the defendant's renewed motion to vacate, nor any other motion that I filed after they voluntarily dismissed it. They filed no resistance. Magistrate Abbott's summary denial of an unrestricted motion while being a stranger to the record demonstrates a clear judicial bias and the invasion of accountability. The trap and statutory retaliation. The record establishes that the defendant was trapped in a hazardous environment. Mandatory presumption. The plaintiff initiated eviction just 7 days after the defendant's January 5th request for accommodation, which was 3 weeks past the initial noise complaint to the plaintiff. The plaintiff's failure to perform trapped the defendants in a hostile and chaotic living environment that was hazardous to their health and safety. Per Iowa Code 562A36, the court was statutorily required to presume retaliation. And again, equity does not aid a volunteer. So the court, having a statutory requirement to find presumption of retaliation, was then supposed to require the plaintiff to prove beyond doubt that it was not retaliation. This is the failure of the court now, not the plaintiff, the court. And by the court accepting the voluntary dismissal by the plaintiff, it traps the merits into a silent record. Designation of record. Pursuant to Iowa Code 631.13, subsection 3, the defendant appellant designates the following items as the record on appeal and requests their immediate transmission to the district court. Electronic recording of hearing on January 26th, containing the plaintiff's admissions of ignorance regarding the 7-day notice and failure of that strict statutory duty. Defendant's request for reasonable accommodation on January 5th, personally served and emailed, triggering the 562A.36 presumption. Defendant's supplemental memorandum of law, which they also denied, outlining the law of the case and unclean hands. Conclusion: the plaintiff's voluntary dismissal was a tactical move to escape the consequences of their unclean hands. Defendant requests that this court exercise its de novo authority to find that the plaintiff breached its strict statutory duties, thereby preserving the defendant's standing for a civil rights claim. Otherwise, if they silence this record, then we have no footing to go forth with our civil rights claim. And that's effectively what they're trying to deny on both sides, the plaintiff and the courts. Again, it's a First Amendment violation for the courts, denying the record of the merits. It's an equitable action. That means it must be on the merits under common law. And under that common law, which is contract, it's plain and clear that the plaintiff admitted they violated the contract, their maintenance. So along with that, we're going to send them a cover letter. Greetings, everybody. I am the Batman. And feel free to drop any comments, guys. I'm going to be reading through, I've got, I think, 9 or 10 documents here that I'm putting out as regards to notices and stuff. So feel free to take notes, which I would hope you are, and send any comments that you feel might be helpful. I'm a newbie at this, actually. Despite my 10 years of research, this is my first real action in these courts. So let's get back to it. Cover letter to the district judge. And of course, I'll have to put in the actual date. I've got to wait a couple days because I can go get some more printing paper. Dear Honorable Judge, the defendant appellant submits this appeal for a de novo review. In other words, go back and review it again. And that's why we're bringing forth that record and the transcripts, because he's going to have to be able to read it. It's got to be able to be read into the record. So to prevent a manifest miscarriage of justice and the tactical evasion of Iowa law, equity does not aid a volunteer. The plaintiff appellee has filed a voluntary dismissal in an attempt to render this case moot or mute, silent, after successfully forcing a constructive eviction. However, it is a fundamental maxim that equity does not aid a volunteer. Having voluntarily chosen to initiate this action and then voluntarily chosen to abandon it only after achieving an extrajudicial result, the plaintiff cannot now ask this court to protect them from a final judgment on the merits. Their voluntary action cannot be used to extinguish the defendant's right to a record of their statutory noncompliance. The doctrine of unclean hands. The plaintiff comes before this court with unclean hands. They seek the equitable favor of a dismissal to shield a record that contains two primary breaches of conscience and law. First, their breach of duty to cure, December 16th. The plaintiff admitted to bypassing the mandatory 7-day notice to cure under Iowa Code 562A.271. And then the statutory retaliation as of January 5th, when we gave him a formal notice called a request for reasonable accommodation. The plaintiff initiated this suit 7 days after such notice. Under the clean hands doctrine, the plaintiff's inequitable conduct in the very matter for which they seek a dismissal bars them from such relief. This court sitting in equity must not allow a volunteer with unclean hands to use a dismissal as a weapon to lock out a $250,000 civil rights action. Conclusion. We respectfully request this court reverse the summary denials of the lower court and enter a final judgment, not a summary judgment, a final judgment on the merits. The plaintiff must not be permitted to wash the record of their admissions through a tactical dismissal. Appellant's statement of the case. Nature of the action. This is an appeal from a small claims forcible entry and detainer action. The defendant appellant seeks a de novo review and correction of errors at law regarding the plaintiff appellee's failure to adhere to mandatory provisions of the Uniform Residential Landlord-Tenant Act and the Iowa Civil Rights Act. The Uniform Residential Landlord-Tenant Act is the 7-day notice to cure, and the request for reasonable accommodations is under the Civil Rights Act. Statement of facts. The uncured hazard. On December 16, 2025, the defendant provided formal notice to the plaintiff regarding a severe environmental hazard and breach of the covenant of quiet enjoyment caused by the upstairs tenant. Pursuant to Iowa Code 562A.271, this notice triggered a strict statutory duty for the plaintiff to issue a 7-day notice to cure to the offending party. The plaintiff admitted under oath during the hearing on January 26, 2026, that they willfully failed to issue said notice, effectively trapping the disabled tenant or defendant in a medically hazardous environment. The 7-day retaliatory strike on January 5th, 2026. The defendant, seeking relief from the uncured hazard, personally served the plaintiff with a formal request and by email for reasonable accommodation based on a documented disability, dementia. Exactly 7 days later, on January 12th, 2026, the plaintiff initiated this eviction action. Under Iowa Code 562A.36, the 7-day proximity creates a mandatory presumption of retaliation. This is the court's strict statutory duty of presumption of retaliation. and it lies on them because it's a 7-day retaliatory strike after we gave the request for reasonable accommodation under the Iowa Civil Rights Act. That's why the court is supposed to take this as a mandatory retaliation within 1 year. A good faith complaint and the landlord proceeds with an eviction, there's supposed to be a presumption. This happened in 7 days from the request for reasonable accommodation, 3 weeks from the original notice of a noise complaint. The plaintiff's use of the court system as a response to a protected civil rights request constitutes an unclean hands approach to equity. See, they're technically supposed to try to mitigate that in private. In other words, before they go to court. That's a Matthew 18, 16, and 17. I went to them in private and let them know, hey, you're doing something wrong, and they didn't hear me. Instead, they brought it to the public court. And now my wife and I had to go in there as 2 witnesses under God. And they're denying that witness. They're denying the truth. Procedural irregularity. Despite the plaintiff's admission of statutory noncompliance, the lower court record was fragmented by a magistrate shuffle involving 4 different officers, specifically Magistrate Abbott, who did not hear the testimony, summarily denied the defendant's Rule 1.9042 motion to record these admissions. This procedural failure suppressed the law of the case, necessitating this appeal to prevent a manifest miscarriage of justice. Conclusion. The plaintiff's voluntary dismissal after forcing the defendant to relocate was a typical attempt to avoid a judgment on the merits. The defendant respectfully requests this court to fulfill its statutory duty to render the judgment the magistrate should have rendered, a finding of statutory retaliation and breach of duty to cure, bring forth the merits of the case, the law of the case. Captain Action in the house. We got L-Tel Baby from the other side of the pond. We got Andy Howtailing says capitalization of words is going to come across as disrespectful and aggressive, and they're going to make it as hard as they can for you as a result. You catch more flies with honey than vinegar. Go ahead and keep on with your babble, brother. You can see in many court documents that they use capitalization all over the place. And in informal documentation, they can suck my dick. Okay? We're talking about the truth, not formality. Get with it. Truth, not formality. Again, folks, we are not held to the formal prerequisites of court, being untrained in the law and legalities, untrained in legalese. That's one of the main purposes of equity, is to keep things simple. Okay, so let's get back to it. The next one I've got is the notice of filing of appeal and application to defer costs. I've got to find out the attorney who exactly is representing them. I'll do that Monday when I get down to the courthouse. And it'll be entered via EDMS, which is just as good as certified mail, and it's considered an electronic signature, so you do not have to do it in front of a notary public. You can just go down there and they have an account for you that is verified, and it enters into what's known as the blockchain. Okay? It is given credence. That's where the credits are in this digital world. Credits are in the blockchain. So entering it into this particular blockchain gives it credit. Understand the simplicity. Please take notice that on this February, the defendant appellant has filed the following documents with the Blackhawk County Clerk of Court. Notice of appeal and designation of record, challenging the procedural errors and the summary denials of the motions to enlarge, vacate under Iowa Code 631.13, application and affidavit to defer payment of costs in form of papyrus, which I'll show you here later. Filed pursuant to Iowa Code 610.1 due to the financial hardship caused by the plaintiff's constructive eviction of the defendants. Request for transcription of electronic record designating the January 26, 2026 hearing as a primary record for de novo review. Notice of intent to sue, statement of intent to sue for damages, notice to counsel. This filing serves as formal notice that the defendant appellant intends to initiate a civil action in the Iowa District Court seeking damages in the amount of $250,000 for constructive eviction, statutory retaliation, and civil rights violations. Basis of the pending claim: breach of strict statutory duty. Your client's admitted failure to issue a 7-day notice to cure to the upstairs tenant pursuant to Iowa Code 562A.271 created a trap and hazardous environment for a disabled tenant. Mandatory retaliation presumption: the filing of the FED action within 7 days, a request for reasonable accommodation in violation of the Iowa civil rights law, constitutes a per se violation of the Iowa Code or section 562A.36. Intentional infliction of medical distress: the bad faith shuffling of magistrates to deny findings of fact regarding a dementia-related housing crisis has resulted in transfer trauma and irreparable harm. Notice of spoliation: you are hereby instructed to preserve all records, including internal emails between Listy Wickham and all tenants, all Waterloo rental registration logs, and all maintenance records. The defendant will seek a spoliation instruction in subsequent civil suit if any of these records are altered or destroyed during the pendency of this appeal. We are seeking $6,500 in punitive damages and $250,000 in actual damages. As this matter is now active on appeal and a notice of intent to sue for $250,000 has been served, you are reminded of your client's ongoing duty to preserve all evidence, including internal communications and city and state registration and licensing records. Any destruction of records during the pendency of this appeal will be treated as spoliation under Iowa law. And if you remember, I issued some notices the other day to the local Waterloo Human Rights Commission and the Iowa Board of Realtors, as far as realtors license, bonds and all that. So we'll see how it goes. Absolutely. I appreciate it, Andy, because I'm behind the 8 ball. I'm a guy that's never studied law. I've only done certain research. I've never got a certificate on a wall saying I'm certified. So I'm a one-man band at this time. So I appreciate all the luck given. Sounds like cross-dressers nowadays need yelled at by their masters, the people. Yes, we need to put them in line. That's what I'm trying to do here, and I'm trying to do it peacefully without fighting, which is of supreme excellence, and that is by using the truth of the words, the substantial truth, over the feigned dismissal and silencing of that truth. Breaking the procedural overlay in court, period. Back to truth and consequences. Absolutely. Truth and consequences and conscience. We have to understand, we have to start being conscious about this stuff, folks. So let's get back to it. The next one. This is affidavit of service for the notice of appeal and designation of record, application and affidavit to defer payment of costs, notice of filing appeal and statement of intent to sue, request for transcription of record upon the following party. And that's where I need the attorney. And it's going to be done electronic service by the court's electronic document management system, EDMS. Or you can do it by certified mail or personal service. Okay. So I'm going to give them an actual notice, affidavit of service in the EDMS, noticing them directly that these documents have been filed and they should go look at them. Then we have statement of financial hardship in support of deferral of costs, impact of constructive eviction. The applicants are currently experiencing extreme financial instability as a direct result of the constructive eviction. We spent every dime we had on this move and even had to wait a day for some money to clear in the account in order to finish paying off the landlord or the moving company what we ended up owing them above the $1,500 that we already paid as a down. Due to the plaintiff's refusal to provide a reasonable accommodation for disability, dementia, and their failure to cure an environmental hazard, noise, the applicants were forced into an emergency unplanned relocation on February 2nd, 2026. Emergency relocation costs. The total household liquidity has been exhausted by the immediate requirements of self-curing the hazardous housing situation. This includes a new security deposit, first month's rent, and physical costs of moving a disabled household member under medical duress. Medical necessity versus court fees. The household income is primarily dedicated to the strict medical needs and specialized care required for a tenant with dementia. Paying the $200 docket fee at this time would directly compromise the ability to provide essential medical supplies and housing stability for a vulnerable senior. Pattern of bad faith. Pattern of bad faith. The plaintiff's tactical decision to voluntarily dismiss the case after forcing the applicants to move has left the applicants unmade whole. We are seeking this deferral to ensure that our First Amendment right to a transparent record and our access to the district court's de novo review are not barred simply because of a financial crisis manufactured by the plaintiff's bad faith litigation. Understand? The bad faith litigation, that's the unclean hands. Coming into equity with clean hands wouldn't be any problem. But we came into equity with an admittance that they didn't have clean hands, and then they're trying to dismiss that uncleanliness and allowing the court to offer them the reward of that removal. That denies our ability to go forth with a civil rights claim by sealing that record. Okay, the next one we have application for a transcript of electronically recorded court proceeding in the Iowa District Court for Blackhawk County. Request for transcript. I request an official written transcript of the electronically recorded court proceedings described below. And I request the appointment. I'm not used to doing these proceedings with my companion as a co-defendant. My apologies. We request an official written transcript of the electronic recorded court proceedings described below, and we request the appointment of the transcriptionist by the district court administrator. Date of proceedings, approximate length was about 30 minutes. Presiding magistrate was Heather Feldkamp. I misstated that in a previous video. It was not Patrice Eichstadt or whatever. It was Heather Feldkamp. And confidentiality, this proceeding was not confidential. And then I give the contact information and I affirm we affirm we are parties involved in this case. We are responsible for, excuse me, and signatures. Next, we've got application to defer payments of costs, requesting information. I got to change this one too. My apologies, folks. Okay, the applicants are currently experiencing extreme financial instability as a direct result of the constructive eviction initiated by the plaintiff. Due to plaintiff's refusal to provide a reasonable accommodation for a disability and their failure to cure an environmental hazard, the applicants were forced into emergency unplanned relocation on February 2nd, 2026. The total household liquidity has been exhausted by the requirements of self-curing this hazardous situation, including a new security deposit, And the next one. This is the appellant's brief in support of appeal, statements of the issues. Did the plaintiff breach a strict statutory duty under Iowa Code 562A.271 by failing to issue a 7-day notice to cure to the upstairs tenant following the defendant's December 16th, 2025 notice of a hazardous environmental condition? And did the lower court commit a reversible error of law by failing to apply the mandatory presumption of retaliation under Iowa Code 562A.36 following the defendant's January 5th, 2026 request for reasonable accommodation? Argument. The breach of the duty to cure, December 16th notice under Iowa Code 562A.271, the landlord's duty is not merely to manage, but to enforce the rental agreement when a tenant's conduct materially affects the health and safety of others. The law of the case, on December 16th, 2025, the defendant provided formal notice of an upstairs tenant's harassment and noise hazard. The landlord's admission. The plaintiff admitted at the hearing that they willfully bypassed the 7-day notice to cure process. Precedent. In Cohen versus Clark, 945 NW2D 747, Iowa, 2020, the Iowa Supreme Court affirmed that a landlord who fails to protect a tenant's covenant of quiet enjoyment from the predictable actions of another tenant is liable for breach of lease. Is liable for breach of lease. By refusing to cure the hazard, the plaintiff effectively constructively evicted the defendant. The 7-day retaliatory strike. The January 5th request. The timing in this case is statistically and legally impossible to ignore. January 5th, 2026, defendant served a formal request for reasonable accommodation for a documented disability. January 12th, 2026, plaintiff filed for eviction. Statutory mandate. Iowa Code 562A.362 states that evidence of good faith complaint within 1 year creates a presumption of retaliation. A 7-day gap between a disability accommodation request and an eviction filing is the ultimate smoking gun. The magistrate's failure to apply this mandatory presumption is a failure of strict statutory duty, once again, this time by the court. The magistrate's shuffle and the denial of justice. The plaintiff's voluntary dismissal was a tactical attempt to prevent a final ruling on these issues. By allowing Magistrate Abbott, a stranger to the hearing, to deny the Rule 1.9042 motions, the court suppressed the plaintiff's admissions regarding their ignorance of the law. This court, in its de novo review, has the duty to render the judgment the magistrate should have rendered, a finding of unclean hands and retaliation. The merits of the case. Conclusion: the defendant appellants respectfully requests this court reverse the summary denials and enter findings of fact that the plaintiff appellee breached its statutory duties to cure and acted in retaliation. And there you have it, folks. Documentation I've got to get out. Like I said, I got to go get the printing paper on Monday. El Michael says, Shalom, all. That's what you call blasphemy of the Almighty. Equity, to come in with dirty hands and get a prejudice ruling for the impure heathen. Absolutely. Appreciate it. Appreciate it, brother. He says, my Lord be with you, brother. Keith. U.S.A.P. says, greetings, friends. Greetings, greetings. You think so? You think so? Andy Hawtailing, this is one of the guys that has a lot of faith in me as a man that tries to correct everybody as he sits in his living room drinking beer and shit and smoking and doing all this shit. as he has no actions in his life to prove that anything he says is worth a fuck. Says they're literally going to laugh together as they read that aloud. I hope they do laugh. Show their heathen asses. Mocking truth. Just like you. Just like you. I had a gal claim that me doing this, even though I state that I'm not a Christian, me doing this was mocking God. That's how little people know. That's how little people know. U.S.A.P says, congratulations on your new apartment, Keith. Enjoy many happy years there. It's actually a house. We have a house to ourselves now. A house to ourselves now. I just did a live today showing everybody the outside. Did a live the other day showing everybody the inside. And the outside part is my favorite because now I get to get back into gardening. So go check it out. And yeah, I appreciate all the kudos and hands up and prayers and stuff. And for you, Andy, I hope you're there. I would hope you're there when all this happens. Because when it comes down to it and I start sharing that $250,000 because I'm supposed to share a tenth of that. That would be $25,000 that I'm going to start whipping out into the community as gifts, as my good tidings, my tithes. You sure as hell ain't going to get none. Second time you've accused me of drinking alcohol and smoking cigarettes. I haven't been sipped alcohol since 2015. I don't smoke cigarettes. Why the lies? Well, exactly. Why the lies? I can tell them anything about you to disparage your character. Why would you expect not? You do it to me, and then you come to my platform and try to egg me on. So here you go. This is what you get when you egg me on. You want to be a bad faith actor? Go ahead and keep spouting your fucking shit on my panel. I'll call you out on it. Go watch this guy's shit. Go see what he puts out. Compare it to the content I put out and see what you like better. No, it's not money is the root of all evil. Get it right. The love of money is the root of all evil. So if I use money and I use it appropriately, that's not the root of evil. Matter of fact, I'm a very humble man. Like I said, this took us out of everything. We have nothing left except our material shit here that we have in our possession. That's it. We have no assets. We have no money saved up. Nothing. We're very humble. We've been living this way for a long time. It took us 6 years to save up $6,000 that we ended up having to spend to move. We didn't save it up to move. We saved it up so we could have a cushion so we could go do things here and there. Now we're going to have a bigger cushion, I hope. And that bigger cushion will only allow me to keep giving more. Been given all my life. I used to do big contracts as an independent contractor. And instead of paying taxes through the IRS, I paid local TIVs, donations directly to the local nonprofit organizations. It was written right into the contracts, 10%. Automatically. Been doing it all my life. See, I started contracting when I was 10 years old with a paper route. And then I picked up a second paper route. And then I also picked up snow shoveling and mowing jobs. And that advanced into year-round lawn care, snow removal, landscaping, gardening, fall cleanup, all kinds of shit. By the time I was 18, I was a made man. Didn't need a fucking job. I already created my own life. I fucked it up. But that doesn't mean I don't still have a life. I know how to contract, and that's the basis of all of this. See, in a contract, you have to be truthful and honest, and that's what I'm holding them to. Their truth and honesty and being able to provide that enforcement, and then they don't, and then admit that they didn't, and admit that they didn't know it was a strict statutory duty to do so means they were operating all this time without a give a fuck. I'm amazed it's taken 8 years. 8 years this woman's been operating like this, didn't give a fuck. And that's the importance of me going forward with this, even if it is all on my own shoulders. I have to do it. It's that First Amendment. See, it's not just my right to know and bring forth that record. It's your right to know so that when I bring forth that record, you can use that same evidence in the same like situations when you get evicted from your apartment or even from your home. See, that's what they're suppressing is the truth. You can do this yourself. You don't need a lawyer. Don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. See, maybe that's what you're afraid of, Andy, is that I'm able to do my research. How redundant. Money is an inanimate object. Of course, I'm referring to money's value, not the paper itself, genius. No, you're saying money is the root of all evil. No, it's the love of that money that's the root of all evil. That's the premise you're missing, dumbass. Just because I have money doesn't mean I love it. There are many people in this world that have lots of money and they don't necessarily love it. They just use it because it provides them a means. They're not using it as an evil source to take over other people or to have authority or control other people. There are many people that can do that. I happen to be one of them. I know how to share. See, that's what it's about. The root of all, the love of money is the root of all evil. Not money itself. It's how you treat it. And if you keep treating money like you love it and you depend on it, that's on you. Because see, either way, again, just like the eviction, either way, whether they got the eviction or we got a dismissal, we were moving. See, this is a long game. As it sits right now, we're living the long game of just having to stack up that money again on our own without the lawsuit. That's the position I look at it as. And the lawsuit is just extra on the top. But it's very worthy of trying to make sure I win that lawsuit, because then that extra on the top, guess what? That extra on the top is the overflowing that wealth onto others. Being able to write a high school level contract doesn't win a court case. Sure it does. If you understand the contract elements, sure it does. Evidently, that's where you're misfed. See, that's the delusion you live in. Because you're one of the first persons that's going to hire an attorney to do it for you. And guess what? They're going to use statute and code against you. Why? Because those statutes and codes, those are contract terms and conditions. Yeah. Contract terms and conditions. Let me show you. Oh, goodness. Don't tell me. Don't tell me. What do we have here? This here is a specific coding, federal regulations, federal acquisition regulations. So when they wanted to acquisition that apartment through a repossession or a possessory equitable action in court for a possessory of that apartment, it's under the federal acquisition regulations. They can't do it without the federal acquisitions regulations. Commercial products and commercial services. contract terms and conditions required to implement statutes or executive orders. And guess what they operate under when they bring the police to execute that possessory order, that forcible entry and detainer? They use the police. Guess what? They fall under the executive branch. So they use statutes, which are contract terms and conditions, to implement the executive orders handed down through a court case. Writ of execution. Writ of execution. It's in the language, and you're the cupcake down there that's going to live under the premise that the police are your authority. You're going to keep living in that fear that the IRS is going to come after you if you don't pay taxes. I ain't paid taxes in 20 years. I beat child support under the same premise. I don't have to pay child support to the state in order for my child to receive child support from me. Just like I donated to local organizations under my contracts, they can receive that directly from me without a third party intervener officiously intermeddling with my private contract. Yeah, writing is what wins in the court. You have to have a comprehension of what you're writing, how to write it. This is why I tell you to get a concise English handbook and a college composition handbook so you can learn how to read and write again. They didn't teach you properly in grade school. They taught you how to babble by remember this and learn how to spell these. That's all they did. And a tip for you, naming the heading of a paragraph as if you are naming a child's adventure novel is probably not a good idea. Great idea for a legal contract. Food for thought. Man, I wish you would feed me more. You feed a lot of babble to people. You're the one that needs that concise English handbook. I'll be here to say I told you so when you lose. No, you won't. No, you won't. You'll still be behind that keyboard running your fucking mouth, and you're trying to tell me I already lost. You're one of the naysayers that doesn't even know how to speak, and you're sitting here trying to convince me that I already lost. What an idiot. Yeah. L. Micah L. says Andy is a clown-like lawyer, Nick, with Malika, a mutual friend, lawful living, and freedom from government.org. Freedomfromgovernment.org. Look it up, freedomfromgovernment.org, and lawfulliving.com. Look them up. What's her other one? Adam and Eve. She's got a third one. See, they own their own acreage. They just moved from a 20 acre parcel of land to a 40 acre parcel of land. And so now they're starting a new channel, Adam and Eve homesteading, I think. Wrong. Convincing a judge is what wins in court. You can be 100% in the right and do everything correctly and still lose your case. No. No. Convincing a judge is what wins in court. If you haven't paid attention, I've been using stuff that should convince a judge that they have a statutory duty themselves, and yet they keep denying it. So we're going to pull out a judicial complaint on them as well as the appeal. And we're just going to keep going up the line, because I guarantee you, if this goes to the Supreme Court, we're not settling for $250,000 anymore. They keep making me work for this. It's going to cost them more. Pure and simple. And you've evidently never been in court. So again, here we are listening to somebody that's never been or done anything and sits there in his chair drinking and smoking. Yes, Adam and Eve Homestead. So go check them out. They're on YouTube. Adam and Eve Homestead on YouTube. I believe it. You punch it in all in one with no spaces and it comes up. Adam and Eve Homestead. Go check them out. Malika and her manslave. And check them out, what they're doing with land, living on the land. And again, like I said, lawful living. All kinds of courses you can take for free on lawful living, as well as some paid courses that get into some deep research. And lots of wins over there, folks. And check out Freedom from Government for merchandise and stuff, as well as other relevant issues to travel rights and identification and things like that. Again, part of the lawful living community. Go check them out. Again, there you go. You're only costing everyone else the money. Sure. Where the fuck do you think the money comes from, asswipe? You seem to think there is a limited supply. You seem to think that it's all an asset-based system in there. No, it's an investment system. And when they start trying to use my name and my wife's name to invest in the case, I've already got set up for the fucking bonds. You evidently don't understand anything that's going on. And yet you're still willing to sit there and run your mouth. Keep running your mouth, Andy. Keep running your mouth. Because nowhere in history does it come from the people that are paying taxes. It comes from the bonding system from the court and the investments they make. Yeah, the judges and everybody get paid by the taxes. But the court registry investment system is where all the money is made in the courts. So it creates a trust account, and those investments are what's used to pay out these hefty suits. If they're hefty suits that the plaintiff can't pay. See, the payment comes from the plaintiff. So the punitive damages might come from the court, and then the court might charge the plaintiff for re-education, as according to the punitive damages. But when it comes to the civil rights claims, that goes against the plaintiff. And see, the plaintiff in this case isn't just the management company, it's the 30-something real estate LLC, the actual owners. And see, when they see somebody coming after their pot for $250,000, and they recognize that the management they hired admitted statutory violations and opens them wide to that civil rights claim, they might be willing to settle out of court. See, that's the guy behind the scene that's going to have to pay out of his pocket. The owner. He's the principal. The management company is the obligee. Excuse me, the obligor. The obligor. He owes the obligation to perform under the Uniform Landlord Residential Landlord Tenant Act. And he failed. So he failed the principal. Now I can go after the principal. So that's who we named in the notice of intent to file suit, is against both the management company and the one that owns it. What's a flat out lie? You think in a civil suit it comes out of the taxpayers' dollars? See, this is your ignorance again. Yeah, if you sue the government, yeah, there's your point on taxes coming out of the coffer. is if you sue the government. But when you're suing private parties, it comes out of their pocket, dumbass. So keep on babbling. Uncle Keith draining the system like a true boomer. Really, I'm draining the system. I put into this system all my life. How am I draining it? If I put into this system, how am I draining it? See, you want to call me the liar as you sit there and make these false projections about me, which is bearing false witness. It's called lying. So go back to your fucking camera and do your own videos, smoking and drinking. Okay? Go have fun babbling to yourself. In the meantime, we're done. You put into it all your life, never took back from it once, despite several times when you could have. So, is that your claim that I didn't put anything into it? Is that your claim that I'm draining the system? Yeah, Joshua Whitestone says, show him the obligor number in the financial index. Yeah, see, he's not familiar with that, and he doesn't want to listen to that. See, I've already done all those videos. Absolutely appreciate it, brother. Bleed it out, Keith. Bleed it dry. See, that's your false projection again. So, bye-bye. Have a good day, Andy. So with that, again, remember, folks, contract terms and conditions are required to implement statutes or executive orders. That means literally that the statutes are themselves contract terms and conditions. So when you take upon a driver's license, there's a statute out there that talks about speeding and sticking within the speed limit. That's a condition. That's a contract term and condition for driving commercially, that you're supposed to stay within that speed limit. It's just like a lease agreement. It's just that it exists in the statutes. That's the terms that you have to follow. Okay? So think about this stuff, folks. And one more on the way out. And remember, I love you, but I don't give a rat's ass whether you love me back or not. That's say I don't care if you hate me. I don't care if you don't respect me. That part's on you. So may God bless you and have a good day.
Gather together to state their demands, trying to govern the work of my hands. They use little policies, neat and precise, to sanitize every opinion and advice. The language you speak is a chain on your tongue. Every statement is borrowed, every anthem is sung. You rely on the script to express what you feel, failing to grasp that your spirit is real. Claim to be fighters, demanding respect, but silence the voices that dare to inject a thought that is different, a view that is sharp. They prefer the sweet silence of a soft, simple heart. My logic is mine, I won't beg for the floor. I stand by my terms and I settle the score. You carry the burden of rules you embrace. I choose the wild path and I set my own pace. They'll call you the problem for breaking the mold, but their own house of glass is fragile and cold. They preach of responsibility, honest and true, then blame everyone else for the things they should do. They point out the errors they want you to see, ignoring the flaws in their own history. You trade independence for comfort and peace, wishing the pressure and hard work would cease. My logic is mine, I won't beg for the floor. I stand by my terms and I settle the score. You carry the burden of rules you embrace. I choose the wild path and I'll set my own day. Keep listening to others and following their laws. I am the creator who finds all the flaws. I answer only to